All right, let's talk about one of the most incredible judicial ideas anywhere in the world, India's Basic Structure Doctrine. This is the story of how a constitution basically grew its own invisible shield, a set of rules that can't be broken, not even by a government with all the votes in the world.
But let's start with a really big, kind of scary question. Imagine a government gets elected with a massive majority. What if they decide to amend the Constitution to cancel all future elections, or maybe just abolish the courts? Could the very heart of a democracy be democratically voted out of existence? That's the huge problem this whole doctrine was created to solve.
Now, what's so fascinating is how different places handle this. You look at Germany, for example. Learning from their own dark history, they wrote something called an eternity clause right into their constitution. It literally says you cannot amend things like human dignity or the democratic nature of the state. Period. But India's constitution, it didn't have anything like that. On paper, it looked like every single part could be changed, and that right there set up a massive constitutional dilemma.
So for the first couple of decades of the Indian Republic, the answer to that big, scary question seemed to be, yeah, they can. The overwhelming belief was that the parliament's power to amend the constitution was completely absolute, no limits.
And this wasn't just a theory, it was tested in court and confirmed. Way back in 1951, in the Shankari Prasad case, the Supreme Court basically gave Parliament a green light. They said, yep, you can amend any part of the Constitution, even the fundamental rights. And just to be sure, they said it again in 1965 in the Sajjan Singh case. Parliament's power was cemented as absolute.
So you gotta get this. For about 2 decades, this constitutional tug-of-war was totally one-sided. The courts just bowed to the legislature. The power to amend meant the power to change anything you wanted. Full stop. But, and here's where things get interesting, in that 1965 case, a tiny seed of doubt was planted. One judge, Justice Madholkar, wrote a dissenting opinion, and in it he asked this revolutionary question. He said, hey, what if amend doesn't mean you can rewrite the whole thing? What if there are some implied limits? Now, it was just a dissent, but that question, that was the first little crack in the giant wall of parliamentary power.
And that little crack, it was about to blow wide open. This moment set the stage for one of the most dramatic turnarounds you'll ever see, where the Supreme Court decided it was time to challenge Parliament head-on.
And here it is, 1967, the landmark Golok Nath case. The court does a complete 180-degree turn. In a ruling that must have just shocked everyone, they said their previous decisions were wrong. Parliament has zero power to take away or even weaken fundamental rights. The judiciary had just thrown down the gauntlet.
Well, as you can imagine, Parliament's reaction was fast and it was furious. They didn't just disagree, they launched a full-on constitutional counterattack. They passed the 24th Amendment specifically to erase the Golok Nath verdict, writing it into law that their power to amend was, in fact, absolute. And then, just to prove it, they passed the 25th Amendment, which chipped away at the right to property. The stage was now set for an absolutely epic showdown.
And that showdown arrived in what is, without a doubt, the single most important case in India's constitutional history, the Kesavananda Bharati case. This wasn't just another court case. This was a battle for the very soul of the Constitution.
I mean, just look at the scale of this thing. They had to assemble the largest bench in the history of the Indian Supreme Court, 13 judges.
And the arguments went on and on. It was a complete marathon, 68 days of intense hearings. The entire nation was watching. And after all of that, the whole thing came down to a razor-thin margin. The final verdict was 7-6. The entire future of the Constitution was decided by a single vote.
And what did that one vote create? This, the Basic Structure Doctrine. And it was, frankly, a stroke of genius. The court found a middle path. They said, okay, we're overturning Golok Nath. Parliament can amend fundamental rights. But, and this but changed everything, it cannot use that power to damage or destroy the Constitution's core identity, its basic structure. Think of it like this. You can renovate a house, but you can't demolish the foundation.
So, this brand new, unwritten rule now exists. But was it just a nice idea on paper, or did it actually have any real power? Well, the government didn't waste any time putting it to the test. And that test came really quick. In 1975, Parliament passed the 39th Amendment, which tried to make the Prime Minister's election totally immune from any challenge in court. The Supreme Court, in the famous Indira Gandhi versus Raj Narayan case, struck that amendment down. And their reason? They declared that free and fair elections are part of the basic structure. The doctrine wasn't just theory anymore. It had teeth.
And over the next few decades, the court just kept adding to this unwritten armor. In the Minerva Mills case, they said that Parliament's limited power to amend is itself a basic feature. How meta is that? Then in S. R. Bommai, they added federalism and secularism to the protected list. And even as recently as 2016 in the NJACHI case, they used it to protect the independence of the judiciary, striking down yet another constitutional amendment.
But, and this is a really big but, this incredibly powerful doctrine isn't loved by everyone. Its very existence kicks off one of the biggest debates in any democracy. Who has more power, the people we elect or the judges we don't?
And you can see both sides pretty clearly. On one hand, supporters say it's an absolutely essential firewall. It stops a government with a temporary majority from becoming authoritarian and protects the rights of everyone. But on the other hand, critics say, hey, wait a minute, where's this written down? They argue it's an invention of the judges, and they ask a pretty tough question. Is it really democratic for a small group of unelected judges to tell the people's elected representatives what they can and can't do?
And that really brings us right to the heart of it all. The Basic Structure Doctrine forces us to ask a fundamental question about democracy itself. Who should get the final say on what the Constitution means and what it can become? Should it be the people who are elected to make the laws? Or should it be the unelected guardians whose job it is to protect it? It's a question with no easy answer.